so many shrimp, I got iodine partners.
My bitch a choosy lover, never fuck without a rubber. Never in the sheets like it on top of the cover. Money on the dresser, drive a compressor. Top notch hoes, get the most, not the lesser. Trash like the fuck for $40 in the club. Fucking up the game, bitch, it gets no love. She be cross country, giving all that she got. 1,000 a pop, I'm pulling business off the lot. I smashed up the gray one, bought me a red. Every time we hit the parking lot, we turn head. Some hoes wanna choose, but them bitches too scary. Your bitch chose me, you ain't a pimp, you a fairy.
A pimp, not a pimp. A pimp, not a pimp. A pimp, not a pimp. We eat so many shrimp, I got iodine partners.
Baby, you been rolling solo, time to get down with the team. The grass is greener on that other side. If you know what I mean, I show you shit you never seen. The 7 wonders of the world. And I can make you the 8th if you wanna be my girl.
Hey, what's going on, everybody? It's Artie of Artie's Corporate Fiction. Hope you guys are doing well. Today we got, and I also have a giant, I don't even want to say it on YouTube, but it's on my forehead. It sucks. It hurts. It's really annoying. But that's not what you guys came here for. You guys came here for some DUIs and some sovereign citizens. So we're going to take a look at two court hearings today, courtesy of I believe it's Team Skeptic as well as OSG, and we're gonna have sit back and relax, have some fun, while I'll also have some Elden Ring playing in the background because that's how it's got to be. So let's get this show on the road. I think all right. So I don't want to say this out loud because I'm afraid you guys are going to test it, and I don't want you guys to test it and waste your money. But I think I might have actually finally figured out the way of being able to get blasted by the jump scare, but you guys don't get your ears blasted. It's a completely roundabout way of doing it. It's pretty cumbersome, but I think it actually works, and I finally figured it out. Please do not test it. I'm really not in the mood. I'm genuinely not in the mood today to get scared to death. But I think I finally figured it out. So all right, let's go. OSG. Well, that you guys will be hearing. That's fine. At least that should be fine. Let's go.
Country Meadows versus Tariq Samara Day and Erica Witherspoon. Case number 23C0276.
Christopher Borkin for the plaintiff.
Tariq Samara Tariq Day.
Thank you. Mr. Day, did you serve this notice to principal? Is notice to agent, it's notice to principal, administrative procedure motion that you filed with Mr. Borkin?
Probably.
It was a.
Sir, my question was simple. Did you file it with Mr. Borkin?
I don't believe so.
You have to file anything you file with this court with Mr. Borkin and opposing counsel, or it's considered not filed.
Ex parte communications.
That's the court rule for any court.
Oh, okay. I must have missed that.
My bad.
So he filed something called affidavit of high prerogative writ of quo warranto.
Yes, ma'am.
It's not something that gets filed in the district court anyway, but he did file that, and I presume he's going to file that with you.
Thank you, Your Honor.
I will do that.
You do that.
Your Honor, my client is here to chime in. If it's necessary to take testimony.
I'm not even sure what this document is. He is filing something here that he wants a fraud of false claims for $30,000, conspiracy $250,000, failure to respond $1 million.
$1 million for failure to respond?
$1 million summons
Wow.
to the court,
That's wow.
which you can't do. I'm not even sure what any of that means. Responsive communications, $250 a page, and then $2,313,500 for review and research of responsive communications.
What? 2-point-something million for research? What? No, Iowa Hank will probably watch that later, but what? Man, and people say attorneys' billable hours are insane. Woo!
$500 an hour, but he says it's 8 hours. So
The property was put into a trust as a trust property, and the subject matter of the trust is the subject matter of this case is under the trust. The case number, account number has been conveyed to trust as well, and I was seeking to have this matter handled with equity.
Mr. Day, I'm seriously becoming very concerned about your mental capacities, which is a very unique situation to have to deal with in a civil case.
Huh.
I'm not sure what to say to that.
This wasn't part of the script.
Ultimately, if just seeking for the plaintiff to provide that the original negotiable instrument wasn't securitized, because if it was invested or securitized, it means that it should be discharged.
Mr. Borkin, do you have a response to whatever?
I would
You have a response to whatever the hell that was?
focus on the complaint that we filed, which was for non-payment of rent. I would
Okay, I didn't know. I knew nothing going in, but from the get-go, I just basically assumed it was non-payment of rent.
indicate that there's still an amount of rent owed to date.
Mr. Borkin, I fully understand that. However, at this point in time, the court just indicated that I have some concerns about his mental capacity as to whether or not he should be trying to represent himself in a court of law at this time. Because I don't think that he fully understands what's happening here today. So I'm not going to proceed unless I feel like he fully understands what's happening, which is a problem.
So the fact that she's doing this, it tells me that she has little or no experience with sovereign citizens. That's basically what I'm getting by her referring him to competency. Because if you're a judge, and if you're well versed in SovCit lingo, you'd be able to discern that, oh, he just bought something online. He's not insane. He's just bought some crap online and is trying to get out of it and move on from there.
Your Honor, I believe there's another defendant on the complaint. I don't know if they're present today.
Is Miss Erica Weatherspoon present with you?
No, she's not. She's currently 9 months pregnant.
All right, first of all, Mr. Borkin, I'm not willing to move forward on this today. I have to do several things. One is I want him to file with you the motion that he filed with this court. So that needs to go to you. 2, I need to research how to do a referral in a civil case. If that can be done in a landlord-tenant case so that he fully understands what's happening, because I don't think he understands the proceedings that are going on right now. And then 3, I'm going to refer him to speak with someone at legal services so that I can at least feel like he's had that ability to communicate with someone. If he doesn't do that, then that's a whole separate subject. Because then maybe I can at least justify moving forward with where we are right now. But at this point, I am not comfortable moving forward.
Your Honor, I would provide my email address and he could send his motion to my email if that's easier.
Thank you. Are you able to?
Yes, ma'am.
Are you able to determine, are you able to see what's in the chat feature, sir?
I think,
Do you know
Okay.
how to get to chat?
no, ma'am. I'm
All
sorry.
right. What you're gonna need to do is look on your phone. Do you see 3 dots at the top of your phone that say more?
I'm currently on a laptop.
Oh, okay. So look at the bottom of your
Okay.
screen. You see where it says chat? You see something in red at the bottom that says 32 or 33?
I do see chat.
All right, click on that and you should see his contact information in there. You need to file this notice, motion, whatever you call it, with him. Okay, so that's first step. 2, you need to, I'm referring you over to legal services so that you can talk to them about the nature of these proceedings so that you fully understand them. Okay,
Okay.
You're back.
and that is, they have hours between 10 and 11:30 on Tuesdays, and then 2 and 3:30 on Thursday. Okay,
Okay.
and then I believe the last thing I said was, once you've served them with that motion, I'm gonna look into whether or not there's the ability to refer for competency, and I'll have that answer when we come back here next week. I'm gonna adjourn it over for 1 week to see where we are with all of this.
Am I not able to ask for a jury trial? Is that a different process?
You can ask for a jury trial. There'll also be an escrow where you have to put your money in escrow until that time comes.
Mm.
Okay.
I don't even know if he knows what escrow
Is that
means.
escrow? Is that something that you all provide?
No.
You have to come to the court and put your money into play it here at the courthouse, sir.
Okay.
And you have to file the proper demand for a jury trial. That's probably why you need legal counsel.
Okay.
Okay. So how much is the rent per month?
Are you asking me, ma'am?
No, I'm asking Mr. Borkin.
Okay. Sorry.
Complete indicates that monthly rent is $1,083.
$1,083. So that's how much you'll need to be placing in the escrow until the trial happens, okay, sir?
Okay. Because I think my partner, she completed something with Michigan Bridges to maybe get some kind of a extension or help or something
Oh my
financially.
God.
That may be true, but if you request a jury trial, you have to put your money in escrow. If you don't, then you waive your right to that jury trial,
Okay.
okay? That's why I'm telling you to go over and talk to legal services.
Yes, ma'am. Yep.
Yeah, it sounds like he has no idea what he's doing.
All right, so I'm gonna bring you all back here on March 15th. You need to serve him with that document, okay?
Yep. Yes.
And then I'll see you here on March 15th. I'm gonna schedule this at 3:30,
3:30.
okay?
Thank you, Your Honor.
You're welcome.
Okay. Thank you.
You're welcome. All right, there's a gentleman here with a phone of Motorola 5G. Ooh, sir, could you unmute and tell me who you are?
Hi, my name is Kevin Hugan.
Hi,
Mr.
Kevin.
Hugan, I called that case.
I have no idea
Block,
what's going on.
I called that so long ago.
I've been on this phone for so long. I had no idea. So that I really just came to court. I don't know.
Hold on a second.
What, all
I
right.
gotta go back and figure out exactly when I called and what happened.
This man was called at 1:50.
1:58 p.m. I called it, and what we do
Adjourned to March 29th at 1 p.m.
is adjourned to March 29th at 1 p.m. So it got,
I've been on the phone for 6 hours, Judge.
Your Honor, sir, I called you. Sir, I called you.
I know. I didn't know how to unmute it. I didn't know. I told you, I rather just came to court. You know what I mean? Like, I missed a whole day. I don't know the time. I can't miss any more work. I have to get to 3:30, please. I can't miss no. Like, I took a half a day off today.
I can't recall this case. The attorneys are gone. There's nothing I can do for you. I called the case and I called the names like 3 times.
I didn't know how to work it though, ma'am. That's not fair. Like, I didn't know what I was doing. I sat here the whole time on the phone. I didn't know what I was supposed to do. Like, the dude, he just said, my baby happened to come in and help me get, she's like, just unmute this. I didn't know. I've been on the phone since 12:50. And it's wow. Okay, I don't know. So what happens now?
You have to be back here. What time, what day?
March 29th at 1 p.m.
That is the date that it was set at, March 29th at 1 p.m. You're lucky that you didn't get a judgment against you today. So,
I understand that, but it could. Hey, I'm at the point.
What you want me to do? The attorney's not even here. We can't handle a case ex parte, sir. That's the next court date. There's nothing I can do about that. If you want to call them to talk to them about trying to work it out, that's on you. But I can't talk about the case itself.
So just wait till 29th at 1.
I don't know if you heard the rest of what I said.
Huh?
I don't know if you heard the rest of what I said, is to call the attorney and try to talk to them about your case and see if you can work it out. I don't know if you heard that part. Please do that.
So call them. So how do I get a hold of their attorney? Do I call them? Do I call the apartment? How do I get a?
Do you have the notice of the hearing, sir?
Yes, ma'am. Yes, Your Honor.
The attorney's number is on there and the attorney's name.
Okay.
Call them.
Yeah.
Okay.
Okay.
Thank you.
I turn out to be the bad guy. This is great. I don't know how stuff like this happens, man.
My God.
I'm just trying to be, I'm on my
bro.
life is
Disconnect.
crazy these days,
Don't
man.
say
I got my
anything
money to pay
stupid.
my rent. Date some scumlords.
Then pay your rent and then it's done.
Ooh.
No, it's not. See, you don't even know the case. It's not about the
Okay,
rent.
fine. Then you need to stop talking in court before you upset me.
I'm trying to hang up. I'm sorry, man. I'm not. I'm trying to hang
You should go.
up.
You
Man,
should
this
go.
is-
Oh. Okay. That's one. All right. All right, let's go to the this old couple.
Looks like Ms. Walsh, are you going to be arguing this?
That's correct. Good afternoon, Your Honor.
Afternoon.
Hi.
I think I see a Jeffrey Lawrence.
Jeffrey Lawrence, Colin Calgill. Then
Oh no, he's actually saying it. Oh no. Oh, I wasn't expecting both of these to be cringe. But here we go. Oh, he's doing the quantum syntax and he's verbalizing it. Here we go.
beneficiary.
Okay. So this is set for summary judgment today. I did have an opportunity to read the motion, the response, and the reply. So, Ms. Walsh, if you want to go ahead and make your argument, then I'll hear from Mr. Calgill.
Thank you, Your Honor. This case involves a defaulted vehicle loan for a recreational travel trailer. The credit union is seeking summary judgment on its claims for breach of the loan agreement, as well as for replevin to obtain its collateral.
Replevin.
A plaintiff has submitted the declaration of
A writ irreplevant is a remedy you can ask the court to take for assistance in taking back property, usually a vehicle. And basically a replevant will actually give you if you win a replevant, you can get the aid of the sheriff's office to help you retrieve your property as well. Gotta add commentary, or else the YouTubes will hate
Derek
me.
Howard, the small claims and foreclosure specialist for the credit union, in support of its motion, as well as the declaration of Michelle M. Bertolino from this office, and the Exhibit 1 there too. Despite all of the arguments that defendants have made in response to the credit union's motion for summary judgment, there are no genuine issues of material fact for trial.
Mhm.
It is undisputed that on or about August 14th of 2020, defendants executed and entered into a retail installment contract with the dealer, McCord's Vancouver Auto Center, for the purpose of purchasing a 2020 Venture 281 VBH KZ Stratus, which is a recreational trailer. And that is demonstrated by the Howard Declaration at paragraph 2 and Exhibit 1. Which is a copy of the retail installment contract. Defendants also admitted in their answer that they did go to McCord's to acquire a travel trailer and entered into a contract. Pursuant to the contract, defendants granted a security interest in the trailer to the dealer, and that's at Howard Declaration paragraph 2, Exhibit 1, pages 1 and 4. There's clear language in the retail installment contract regarding the security interest. The contract was subsequently assigned to the credit union, and that's also shown at Howard Declaration paragraph 2 and Exhibit 1, page 3. There's clear language assigning the contract to the credit union. The credit union perfected its security interest in the vehicle, as notated on the Washington State Vehicle Certificate of Title for the trailer, a copy of which is attached as Exhibit 2 to the Howard Declaration. And that certificate of title shows defendants as the registered owner and the credit union as the legal owner of the trailer. Defendants defaulted under the contract by failing to make monthly payments as agreed, as stated in the Howard Declaration at paragraph 3. The last payment made on the loan account was on or about December 28th of 2021 in the amount of $359.24, as shown in the Howard Declaration at paragraph 3 and at Exhibit 3, which is a copy of defendant's December 2021 monthly statement showing that last payment that was made. Defendants admit in their answer that the last payment was made in December of 2021.
Okay.
The trailer has not been surrendered or repossessed at this time, as supported by the Howard Declaration at paragraph 3, and defendants have admitted this in their answer as well. The balance owing to plaintiff is the principal sum of $35,928.21, plus late fees in the amount of $53.88, plus accrued interest in the amount of $1,325.37 through July 21st, 2022, plus interest accruing on the principal at the contract rate of 6.66% per annum from July 22nd, 2022 until paid. And that is set forth in the Howard Declaration at paragraph 4 and is also supported by Exhibit 4 there too, which is a copy of the payoff statement for the loan, and also Exhibit 3, which shows the principal balance on the loan that has not changed since the last payment was made in December of 2021. No, the amount owing may be reduced by the net proceeds from the sale of the trailer, after repossession and sale of the trailer. But pursuant to the terms of the contract, the credit union is entitled to recover its attorney's fees and collection costs. And that's at Exhibit 1, page 4, paragraph 3C. Now, once a motion for summary judgment has been made and supported by affidavits, the opposing party may not simply rest on the allegations in its pleading, but rather must set forth specific facts in affidavits or otherwise as provided in CR 56, showing that there is a genuine issue of material fact for trial.
Yep.
And defendants have not done so here. While they have submitted many pages of inadmissible hearsay,
gobbledygook,
including excerpts from several books and alleged excerpts of statutes and constitutional provisions and postal tracking information and other materials. Some
with the colon, postal - court, colon, yada, yada, yada.
Documents that appear to have been drafted by defendants themselves that have names like conditional acceptance or bill of exchange or a declaration of the Naturalization Act of July 1779 for Jeffrey L. Cowgill status correction to the land and soil jurisdiction, not sea admiralty.
Admiralty.
The defendants have not set forth specific facts in affidavits or otherwise as provided by the rule that would show that there is a genuine issue of material fact for trial. In their answer, they requested that the credit union fix their credit and that damages be assessed against the credit union for $50,000 based on allegations that the credit union allegedly rejected tendered payment under the UCC. And
UCC, more than likely, they probably sent them a BS A for V promissory note that they think is actual hard cash. I can see it. I've been in this space too long that I can actually visualize the paperwork that they submitted. That's how long I've been in this space. They probably did an A for V or a promissory note that they thought would be that the bank is required to accept as good as cash, like a literal piece of paper should be good as cash, or just told them to go take it out of their freaking secret treasury account. Goodness.
Almost 250 pages that they submitted in their response to the motion for summary judgment. They elaborate on the allegations that the credit union rejected payment that defendants allegedly made by submitting a Form 1099-A, like an IRS
1099-A,
form, and a promissory note. But those forms of alleged payment are not legal tender, and the credit union is not obligated to accept them as forms of payment. A 1099-A form is not a form of U.S. funds. And defendants admit that they have not made payment on the loan since December of 2021. So in short, defendants have not contradicted and cannot contradict the facts that are set forth in the Derek Howard Declaration, with any admissible evidence. And as set forth in plaintiff's reply brief, none of the arguments raised by defendants in their response motion create a genuine issue of material fact. If the court would like, I can go through, kind of summarize those additional arguments that the defendants have made. First, the defendants have not created a genuine issue of material fact regarding their entry into the contract. Defendants have, kind of complained about the copy of the photocopy of the contract that.
And there it is. So basically, this sounds exactly like people try to do when they try to get out of paying their mortgage. This time it's for a tractor trailer. They probably sent like a list of demands saying, I want proof, a signed original copy of the contract, wedding signature, and we do not accept photocopies. Yada 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 yada. I see this from a mile away.
Is attached to the Howard Declaration. However, the Washington Rules of Evidence do allow the admissibility of a duplicate to the same extent as an original, unless a genuine question is raised as to the authenticity.
Exactly. The only time where you would say that, okay, we want an original copy in court is if you actually, if they, the family, or the Jeffrey Lawrence Calgill can say, hey, that's not my signature. Here's a copy of, here's several copies of checks I've signed, or here's other copies of signatures that I have, and it looks nothing like this photocopy. Once that's done, then the court will say, okay, there is raised a genuine issue of authenticity. So now we're going to want an authentic, like a wet ink, the original signed agreement for them to produce.
City of the original, or in the circumstances, it would be unfair to admit the duplicate in lieu of the original. And that's in ER 1003. But defendants have not raised a genuine issue of material fact regarding the authenticity of the original contract. In fact, they admitted in their answer that they did go to the dealer and that they to acquire a travel trailer, right, and that they entered into a contract there.
So they basically admitted to everything. They admitted to going to the dealer. They admitted to signing a contract. They admitted to making payments up until a certain point, right? I can't recall if she said that they had been making payments. They admit to everything, so they're kind of SOL here.
They also made payments on the contract, the last one being in December of 2021.
Yeah, they did pay.
They admit that they're in possession of the trailer, which has not been repossessed. Defendants' other arguments in their written response also appear to acknowledge that they owe amounts under the contract, as they argue that they attempted to make payments.
So basically, it sounds to me that they went SovCit in the middle of these proceedings. Because, it sounds to me that they went full SovCit in the middle of these proceedings because no guru would tell them that they would have to, they would put in their answer that they admit to everything, that they admit that they made a contract with the credit union.
They're under. And as stated in the Howard Declaration, the contract attached to the Howard Declaration as Exhibit 1 is a true copy of the original contract that is kept in the regular course of business in plaintiff's loan files. And plaintiff has demonstrated that the contract and other business records that are attached to the Howard Declaration are admissible under the hearsay rules business records exception. Defendants argue that the Howard Declaration is not hearsay because Mr. Howard was not sworn in. However, that argument is not persuasive because the Howard Declaration is signed under the penalty of perjury under the laws of the state of Washington. If you look at Howard Declaration at page 3, that is so. By contrast, the defendants have not submitted any affidavits or any other evidence under CR 56E that would create a genuine issue of material fact regarding their entry into the contract. Second, defendants have not created a genuine issue of material fact regarding their default. They contend that they didn't default under the contract because they tendered 3 separate negotiable instruments per the Negotiable Instruments Act of 1881 in compliance with the UCC. And they argue that, these are twice that they sent the credit union a 1099A form, and that the form was supposed to be used by the credit union to obtain payment on a defendant's loan from the IRS. However, a 1099A form is not a negotiable instrument. It's a IRS tax form that is required by the IRS to be filed after property used in a real estate loan has been foreclosed or abandoned.
Yeah, I don't know what guru they went to that thought they could pull this time. Oh, I do have an idea. It's Christopher Hauser. I think that's his name. I'm in his Telegram group. He's a big advocate of the 1099A scam.
A 1099 form has nothing to do with defendant's vehicle loan with the credit union. And the IRS instructions expressly provide that the term property does not include tangible personal property, such as a car held only for personal use, which is the case with the travel trailer. Defendants also argue that they sent a bond coupon in the form of a promissory note to the credit
And promissory
union as
note.
an attempted tender of payment under the contract. However, defendants have not submitted any admissible evidence to support that proposition. And even if they had, that is not a valid form of payment. A promissory note is essentially a promise to pay a debt, which defendants did by entering into the retail installment contract.
Exactly.
Which then in turn requires that they make monthly payments using U.S. funds in conformance with the schedule required under the retail installment contract. Defendants also have not created a genuine issue of material fact regarding the plaintiff's damages or about plaintiff's right to immediate possession of the trailer. Plaintiff has established its damage.
Thanks, Paul. Do prosecutors have to orate this long, or are we just lucky to? No. This is a motion for summary judgment, a file, and this is not a prosecutor. This is the credit union's attorney, the plaintiff, credit union's attorney, the plaintiff's attorney. And this is a motion for a summary judgment, and she's arguing her case as she's the moving party, and she's basically giving an oral argument as well as what she's already provided on the papers. And then once that's done, then the defendants will have their chance to respond, and God knows, I can't wait. But so far, she's doing everything solid. I mean, she's made her case. She's put in all the elements that reiterating that there was a contract made. They were making payments. They stopped making payments. They have a right to obtain possession of the property if they win, and call it a day. What is this? I'm sorry. Dingbat, thank you for the $9.99 super chat. Have you heard of Christopher Hallett? Sovereign is a guru lawyer who was killed by one of his clients. Are still up. The woman in the chat with him was his murderer. I have heard. Okay, I've heard of that incident. I didn't know who the guru was. I think I forgot who the guru was, but I do recall that incident of where the woman killed her guru. That was a wild
is by the Howard Declaration at paragraphs 3 through 5.
I'll have to check that out though, but thank you.
As demonstrated by the defendant's monthly account statement for December 2021, showing the last payment that they made on the loan, and the payoff statement for defendant's account dated July 31st of 2022, defendants do owe the balance that's set forth in the complaint and the Howard Declaration, and defendants have not submitted any evidence to contradict those undisputed facts. Defendants have not created a genuine issue of material fact regarding plaintiff's right to immediate possession of the trailer as a consequence of their default, and plaintiff's security interest in the trailer as notated on the vehicle title. Under RCW 62A.9A-609, after default, a secured party may take possession of the collateral pursuant to judicial process, which is what plaintiff is seeking here. And plaintiff is undisputedly entitled to judgment as a matter of law on its Riplevin claim. And finally, none of the other allegations by defendants create a genuine issue of material fact regarding their entry into the contract, their default thereunder, and their plaintiff's right to damages and to Riplevin. For example, defendants contend that plaintiff did not adequately validate their debt upon request. And the declaration of Michelle Bertolino from my office and the Exhibit 1 thereto demonstrates that this office did adequately validate their debt, and the enclosures to the debt validation letter sufficiently supported the debt that is owing by defendants. Defendants also contend that plaintiff violated the Graham-Leach-Bliley Act by allegedly sending copies of defendant's credit application in an unredacted form to plaintiff's attorneys. However, the Graham-Leach-Bliley Act does provide at 15 U.S. Code Section 6802 sub E sub 4 that a financial institution is permitted to disclose non-public personal information about individuals to its own attorneys to the extent necessary.
Well, yeah.
And so even if plaintiff provided a copy of, an unredacted credit application, that would not violate the act as a matter of law, given that this firm, the attorneys for the financial institution, is retained to pursue collection on this defaulted account. In short, defendants have not articulated a valid basis for any claim against plaintiff for violations of any statute, and more to the point, defendants have not raised any genuine issue of material fact that would preclude summary judgment in this case on the breach of contract and replevin claims that the plaintiff has brought. So the plaintiff asks that the court enter the revised proposed order granting summary judgment to plaintiff, and that the court enter the revised proposed judgment, excuse me, with attorney's fees awarded to plaintiff in the amount set forth therein, supported by the fee petition that we also have provided to the court and to defendants. Plaintiff has left a blank in the proposed judgment for the court to award additional fees incurred for preparation for and attendance at the hearing today. And if the court has any questions about that, I'm happy to answer. But with that, I can stop there for now. Thank you, Your Honor.
All right. And he's muted.
You're muted, Your Honor.
Relatable.
Mr. Cowgill, I did, just so you're aware, I did read through your response and attachments. So if you have, I'd like to hear what argument you have in response to counsel.
Without prejudice, I, Jeffrey Lawrence, Cowgill, with Teresa and Cowgill, the beneficiaries making special appearance sui juris propria persona under fraud, menace, and duress before fiduciary basher.
Oh my God, I had no idea. Oh, no! I had no idea this was going to be a freaking a bingo
Looks like
bingo
Ms.
card.
Walsh, are you going to be arguing this?
That's correct. Good afternoon.
I, Jeffrey Lawrence, Cowgill, with Teresa and Cowgill, the beneficiaries making special appearance sui juris propria persona under fraud, menace, and duress before fiduciary basher. This is a Sesticate trust action, which you are now a real party in interest to. I'm the living man on the land and soil. The dead entity, all caps, Jeffrey Lawrence Cowgill, was expatriated, and I, the living man, have an unrebutted UCC-1 lien and security agreement with the all-caps entity, and Gary Basher serves as the entity trustee in a fiduciary capacity. Virginia law further provides to authorize such filing, the debtor must do so in an authentic.
Thank you, Red Streth, of the $9.99 super chat. Thank you for taking the time to explain our argument. It really helps the law nerds and the shenanigans. Yeah, I mean, this is basic. It's basic stuff. You have to be a genuine issue of material fact in the summary judgment motion, and they have none. And honestly, it's a slam dunk.
Record by authenticating or becoming bound as a debtor by a security agreement, or 3, by acquiring collateral. I have supplied that to you, that there's a UCC-1 claim. The plaintiff's agents are outlandish, stating Federal Reserve published documents are hearsay. Statutes and constitutions are admissible under 56B, as it states, the defendant may move with or without supporting affidavits for a summary judgment in such party's favor as to all or any part thereof. Since the plaintiffs have violated RCWs, UCCs, and U.S. codes, among other laws, these laws are fact and admissible per CR 56B. The plaintiff says the conditional acceptance is a nonsensical document, yet it is in Black's Law Dictionary under conditional
Black's Law Dictionary.
The definition is an engagement to pay the draft or accept the offer on the happening of a condition. A conditional acceptance is in effect a statement that the offeree is willing to enter into a bargain differing from some respects from the proposed or the original offer. The conditional acceptance is therefore in and of itself a counteroffer.
No,
We
it's not.
conditionally accepted the offer of the plaintiff, but the plaintiff ignored us.
Yeah, and they're not obligated to accept your counteroffer. They're not obligated to accept your counteroffer. That's not how that works.
Knowing that the conditional acceptance stated acquiescence would void the original contract.
And that's a BS term of the agreement. Oh god, I'm gonna lose I lost my runes. Fuck. This is what happens when I do law stuff while trying to play Elden Ring. I have self-complaint. I lost 60,000 freaking runes. Damn it.
Combined with the Esquire Scroggins letter is fact and evidence to the plaintiff receiving the bills of exchange that they did not return. The plaintiff's agent, Esquire Bertolino, admitted they received them as well. What qualifications does any of the plaintiff's agents have to declare what is and is not a bill of exchange?
Okay, so to now that it's pointless and I'm calm now. Imagine you had an agreement with Comcast. Let's use those SOBs as an example. I have a 2-year agreement with Comcast for $80 a month for 1,000 gigabit per second download internet speed or whatever. And let's say a year into the contract, I send Comcast, okay, I want to actually make a counter offer. I'm only going to pay $5. Now only going to pay $5 a month for 1,000 gigabits. And I have to tell them, and if you don't respond to this, it'll serve as an automatic agreement to my terms. And I send that out to freaking Comcast. Imagine if that condition was to be accepted as valid. Yeah. Imagine, yeah. You all can see what would happen there.
Since the plaintiff's agents, the Esquires, lied about the redacting and have submitted evident affidavits that they are not qualified to submit, how can their words be trusted? They are not bankers, nor is Mr. Howard. What is his qualifications to make such declarations? He looks at a piece of paper, the plaintiff's agents hand him, and he takes it as gold. I have people at work that know federal and state policies. And
you know people? Is it the guru that you pay $250 for your packet of BS? Is it him?
And procedures, they're clueless as to what those policies and procedures are for. How can Mr. Howard be trusted acting as an entity's agent? No offense, lawyers lie all the time.
Oh, my bad.
Fact, Agent Howard produced a terrible photocopy that has a signature on it for the dealership that is not on our copy. Who signed the contract? Can the plaintiff's agents prove that an authorized representative for the dealership that is delegated by the plaintiff signed that contract? The plaintiff wants to rely solely on the contract. So let's talk about the contract. Who signed it for the dealership? Why hasn't the plaintiff gotten an affidavit from the dealership? Because they don't know who signed it. Washington rule does state that the photocopy can be used in the original's place unless there's genuine question of the original. And that alone poses a major question. Where is the original? Is a signature on the original more legible? Is there any other evidential factors on the original that can give us the answers to that truth? On the UCC, we did tender for payment bills of exchange, who the plaintiff's agents are not qualified to decide with their opinion what is and is not a bill of exchange. And as for where the bills of exchange are, ask the plaintiff. What did they do with them? They did not send them back. What did they do with them if not monetize them for gain?
They probably trashed them. Assuming he's talking about their counteroffer, they probably shredded them.
Esquire Bertolino states that the instructions on the 1099A state tangible property is not included, yet the exact wording is no reporting is required. Meaning you don't have to, but you can. It does not say no tangible property, so Esquire Bertolino lied. The plaintiff has violated many UCCs, U.S. codes, not just 12 U.S.C. 5511B2. C codes and definitions on everything that the plaintiff has violated, and I have proven the facts. Why didn't the plaintiff return the documents they say are not bills of exchange with an explanation or dishonor? Why wait and have Esquire type up some bunk letter and still not return those bills of exchange? When you're doing something and you find out that there's fraud or some shenanigans going on, you stop. That would explain why we made payments until we found out that there was fraud.
Oh, here we go. This will be good.
Payments in fiat currency were being made until we
Fiat
discovered
currency!
the truth, and the plaintiff's agents violated laws and codes. All they had to do is return the bills of exchange with dishonor and or validate the debt or answer the conditional acceptance. Instead, they ignored us.
Yeah, they're not obligated to respond to you. Period. End of. They're not obligated to respond to your BS.
That's why we're here. The Federal Reserve publications, like Hearing the Truth from the Horse's Mouth, said exactly how banks operate. How is that not fact? The Federal Reserve dictates what the banks can and cannot do. I'd say their publications are not only admissible, but damning to the plaintiff's complaint. As the plaintiff, they have to prove their complaint, and not only are there holes in their contract theory because of the signature, but it begs the question, why are they dismissing the UCC, which all banks and courts are bound to? And why didn't they rebut the UCC one?
Because you're citing to the UCC 1 incorrectly. This kind of transaction would invoke this UCC. I'll concede to that. Or at least whatever Washington State's version of the UCC that they passed. This would actually fall under that because this is obviously a contract for goods. But they're using it wrong, of course.
And as for the Leach Act, I submitted the copy to the court from the plaintiffs behind a sealed financial record. There's no explanation for these agents or their office to be passing around sensitive information
Yeah, they are.
that the agents do not need. So they did violate the act.
No, they didn't.
What is their confidential material protocol? Who has seen the documents and where is it stored? How was it sent to the plaintiff's agents? By mail, fax, email? So how can you tell me it was secured when they didn't take the precaution?
The Russians got it now. There it is. You got it.
When they send it to me in regular mail, not certified. The plaintiff never asked if they could share our personal information of that magnitude.
They're not obligated to if they're sharing it only with counsel.
This alone sets forth facts to either dismiss or send this complaint to trial, so the plaintiff's agents can be questioned. Put the qualified bankers on stand so we can find the truth. The plaintiff's esquires are not qualified to speak on the plaintiff's behalf. Mr. Howard is not a banker, so neither is he.
Okay.
I sent, and if you use it without prejudice, like I have, a 1099-A can be anything I want. I can write a bill of exchange on a blank piece of paper. It's what they do with it. They didn't send it back with dishonor. They didn't send it back at all. All they said is, well, now we're going to limit how you can and cannot pay. And so they violated the UCC.
No, they didn't. No.
And with that, I'm done.
Okay. Any brief response?
Thank you, Your Honor. The retail installment contract expressly provides that that the borrower the borrower agrees to pay the amount financed and the finance charge in U.S. funds according to the payment schedule below, as explained on
there it is.
Section 1 on the back. That's at Exhibit 1, page 2. It's undisputed that the defendants did not do so, that they defaulted under the terms of the contract. They don't dispute that they received the trailer. They don't dispute that they received this loan. They don't dispute that they made payments under this contract. They knew how to make payments under this contract. And they don't deny that they stopped making those monthly payments. There is no genuine issue of material fact that they entered into the contract, that they defaulted under the terms of the loan, and that they owe the amounts set forth in the Howard Declaration. It's, not appropriate for defendants to malign attorneys generally or
It's also a big no-no to just say straight up that opposing counsel is lying. it's like it's an ethics thing. You could say opposing counsel is incorrect on the facts. Here are the actual facts of the case. There are ways of being able to say that no, the other attorney is wrong without calling them a liar.
My colleague, Ms. Bertolino, in this court, with no evidence, no admissible evidence that would support any of the allegations that defendants have stated here today. There is no demonstration, no allegations, no demonstration of fraud by the credit union or by anyone. There is no defendants just simply have not created a genuine issue of material fact regarding the credit union's claim for breach of contract or its entitlement to replevin in this case. And that is
just leave it there.
Those
leave
are
it at that.
the plain facts.
So I got one question I have, which is not necessarily germane to my decision. Does your client still have the bills of exchange that were submitted?
That I don't have an answer for you today.
Your Honor, I've asked for them back and they just blatantly ignore me.
All right. Well, when I look through this, I mean, there's a lot of interesting theories that are kind of flowing all through this. What it boils down to, from what I gather, and there seems to be undisputed, is you folks went in, you bought a trailer on time, agreeing to make payments of some amount, pay it off. At some point in time, there was an issue arose where you decided to do something different, and then no more payments were made. There were some submissions of bills of exchange as an attempt to make a payment, as well as a 1099 as an attempt to make a payment. And I guess my answer to that is those probably would not be something you could walk into Safeway and buy a banana with, because it wouldn't be considered regular.
Hey, Theo, thank you for the 99 cent super sticker.
Of buying things in a retail situation. They may work in a UCC type thing or something like that. This is simply a consumer contract to buy a trailer and make payments on it. And when you're all done, you get the title. The credit union, it appears without any objection, has a security interest, which is indicated in the title as the legal owner.
Yep.
And I've not heard, I mean, there may be some other claims, but that you may have against them. I'm not making an assessment of that, because even if you did, it would not upset the contract to buy the trailer. So, I mean, you buy the trailer, you got to make the payments, you make the payments, they get the trailer back. So I am going to grant the motion for summary judgment.
There it is.
In doing so, I want to just give you some guidance, sir. What will ultimately happen is they get the trailer back and then they sell the trailer to somebody else. They apply the funds they get from that against the bill that's still owing. So the more money they get out of that trailer, the less money you end up having a judgment for. Does that make sense? So it's in your best interest not to do anything to the trailer. It's probably in your best interest to hook it up and drive it down to the credit union, because that would save some costs.
Oh yeah, I don't have a truck to do that, so they can come get it.
Oh, okay. I'm just trying to point out it's.
And so my copy of the contract not having a signature from the dealership doesn't matter.
It really doesn't.
Why would it have a signature from the dealership? You didn't get the loan for the money from the dealership. The dealership didn't give you the money. The credit union did. Why would their signature be on the loan?
And you being the trustee in this case doesn't matter?
Well,
He's
I'm
not a
but I'm
trustee.
judge.
You are, because I appointed you one
I didn't accept
as the
that.
beneficiary, because I'm not to do that.
Okay.
You're about
I'm
to do
not
that.
able
Okay.
to accept that as a Superior Court judge.
So what about them just putting out our social security numbers without our say so? Like they could have completely ruined our credit. Someone could have those numbers.
A 1099-A is in relation to a mortgage. It's in relation to real property, not for tangible goods like a car or a trailer.
And be doing damage to us right now.
Well, if those were passed to the attorneys as part of the collection, then that would be something that would be allowed. If that was sent out beyond that, obviously that's a separate issue. And if in fact that were a claim that were proven, there may be something there. But again, that doesn't affect the contract. Those are all other claims that you may have. And I'm not saying you do or you don't, because I don't know enough about those, even based on all the information that you filed. You filed, and I read through all the stuff you filed because it's what I do when I do my job. So,
so can we have those forms of payment back?
Oh,
I
I
would
just
Order
realized
them
this is
to
the life.
return those to us?
well, I think it's appropriate if there's some value in those, those should be returned to
There's a lot of value in them if they still have them. And if they don't have them, then
Then what happens if they don't return them?
They really want their BS paperwork back, I guess. All right, fine, whatever.
Well, that'll be a different lawsuit. It's not part of this.
Okay, so what I'm asking is, can you order them to return those bills of exchange?
Your Honor, that is not there is no motion that is not before you today.
Well, see, I'm not a practicing attorney. I don't need to do all this attorney stuff.
Mr.
Yeah, you
Calder,
do.
but
Shut
one
up.
person talk at a time. First off, the court has a fair amount of discretion to authorize relief in a case like this.
But they can do that, yeah.
If part of my decision is that the credit union needs to return the bills of exchange, then they need to return the bills of exchange.
Which I would appreciate.
So,
Please and thank you.
so I am looking here and only for some reason. Hold on a second. A lot of paperwork came through here this week.
Sorry.
Stuff. No, it's not you. I just had a lot of orders for today and I don't looking sure. And for some reason, I am not finding those proposed orders. So counsel, if I can have you submit I think there were proposed orders filed in the case.
Yes, and they were submitted with our reply brief in the same package as the reply brief. There's a proposed order granting the summary judgment, as well as a proposed judgment awarding attorney's fees. And Your Honor, we did ask that the court, we did leave a blank in the judgment so that the court could also include some attorney's fees for the preparation for an appearance at today's hearing.
All right. Well, if you want to resubmit those, I have proposed that were filed in the case, but I don't have anything that I can actually use.
Okay.
Have you submit new ones? If you want to include a certificate for attorney's fees specifically related to today's hearing, I can consider that as well. I mean, I don't have anything to base it on at this point.
Okay.
So for you folks, I am going to include within that order that the credit union will return the bills of exchange that they were provided.
Your Honor, I just want to interject that I'm not certain whether the credit union has those, but if they do, and
This order may be returned. That'll be a different issue if they don't.
Okay. Thank you, Your Honor.
Thank you.
I'll await orders, and when I see them, I will sign them and enter them and return copies to everybody.
Your Honor, could I jump in for just a second? This is Lisa Waldvogel calling.
Who this?
Inquiring about item number 2 that's on the docket. I have a 3:30 meeting with just a ton of agencies, DDA, it's a WISE team, with service providers, client of ours.
Counsel, I will, when I finish this hearing, I'm scheduled to go.
What the hell?
Today. I'll get
Who
to your
are
case
you?
as soon as I can.
Okay, I was just hoping we could do it so I could attend my 3:30
I
meeting,
understand.
but I understand.
I would appreciate letting me finish the hearing I'm doing. before
Seriously,
interrupting.
why are you
Oh,
butting in?
thanks, Your Honor. I thought you were done.
Are we done? I gotta
Idiot.
get my daughter.
All right, so council, if you can provide those, I will send out signed orders to everybody and the addresses we have on the file.
Perfect. Thank you.
Okay.
Thank you, Your Honor.
Was that it? Oh, that's it. Yeah, that's surprising. They got ramrodded. All right, we got our last one of the evening.
I'm not drunk. I haven't drank anything all day long. I will pass the BAC, whatever. I'm not going to be driving drunk with my grandson in the car. What the
Alright.
are you doing?
Putting the cuffs back on you that you slipped out of.
Stop! I want my phone and I want to call my goddamn lawyer right now. I hope you guys have your body cams on. Do you have your body cam on?
Yep.
Hopefully you guys lose your jobs. Let my grandson run around on the road by himself.
The whole family lives together on Curtis Street there in Hatley, but I got the kid and the dog in my squad for now. So
Oh, holy crap.
For what? My car
Because-
slipped down in the ditch.
Right, and I'm concerned because you have how old is Jasper?
3.
You have a 3-year-old in the car with you.
Yes, and we're going to Nori Lake, and I hit the
understand
wrong
that.
road, and I was trying to back up, and the freaking mud ate my
So
tires.
for my peace of mind, I want to check to see if you are okay to drive.
Fine.
Is that something that you are willing to do?
Fine.
Can you take your glasses off and put them on the car? Have you had a head injury in the past 24 hours?
I'm not even going to speak on that.
Okay. Have you been to the dentist in the past 24 hours? Do you have anything that can prevent you from doing any walking, turning, anything like that, lifting a leg off the ground? Yes? What are those conditions?
My boyfriend beat the crap out of me the other night
Okay.
and
Oh my God.
locked me outside butt naked. I slept in my trunk of my car.
Okay. Did you go to the doctor for that?
No, because I don't want to see him get in trouble for it because it's my only place of living.
Okay. Do you wear glasses or contacts? Okay. Do you have contacts in right now? Can you see the tip of my finger without your glasses?
Barely.
Barely? How about, can you
Yeah.
at least follow it? Yeah? Okay. And are you willing to do these tests for me? They're voluntary.
My leg's fucked up. He threw
Okay.
me outside butt naked, and I should probably go to the doctor about my leg, but
Okay. So if you feel like you can't do the walking portion, we'll discuss that once we get to it, okay? Alright, can we start with me checking your eyes then?
go for it.
Alright, can you stand with your feet together, arms at your side? Stay in this position and don't move until I tell you to. Do you understand? Okay, can you see the tip of my stimulus?
Yes.
Okay, with your eyes only and without moving your head, follow the tip of the stimulus.
It's blinking.
When
If I
you-
have a seizure, it's not my fault.
Do you usually have seizures?
I'm epileptic.
Okay, when was the last time you had a seizure?
2 weeks ago.
Do you take medications for it?
I have to go to the Marshfield Clinic next week. I have a...
And do not move your head. Do you understand?
Yes.
Alright, same thing. With your eyes only, follow the tip of my pen, but we're going to go up and down. Remember, stay in the starting position. Up and down now, okay? Okay, Haley, you can relax. Okay, so now we're going to move into the walk and turn. So do you feel comfortable? You can...
I haven't been to the doctor for my leg yet.
Okay, is it hurting right now?
Yeah, you can see exactly where it's all swelled up.
Okay. Are you willing to at least attempt it?
I can try, but I can't guarantee anything
Okay.
good because that thing is hurting like a son of a bitch. I know I need to go to the doctor, but
Sure.
my fiance, I can't say anything because it's the only place I have to go.
Okay. All right. So we're gonna use this line in front of us. So stand in front of my car. You can put your glasses back down. So what you're. Yeah, that's fine there. Okay. You can see.
I'm gonna limp. I'm letting you know.
Okay. Well,
It's not
like
a bitch hurts. I can't pick.
it sounds like I said, they're voluntary. So it sounds like you said you wanted to try it.
No.
No?
I won't try it.
Okay. You don't want to do that. Okay. What about the one leg stand?
I could do it on this
Hey.
leg, but I can't do it on my
Okay.
other leg. Maybe.
Okay.
I don't know.
All right. So just stand right there.
I mean, as you can see, I've got f***ing blood running down my leg.
Yeah, that's probably from crashing.
No,
Yeah,
it's
probably.
from going through the bush and
Or
trying to
through the
push
bushes.
motherfucker.
Okay, so stand with your feet together, arms at your side. Stay in this position until I tell you to do otherwise. Do you understand? All right, when I tell you to, what I want you to do is lift one leg of your choice, approximately 6 inches off the ground, with your foot pointed out. Look at your foot and count in the following manner: 1001, 1002, 1003, until I tell you to stop. Do you understand?
Yeah, but I can't do that.
Okay, you can choose what leg you lift off the ground.
Yeah, but I can't do that.
You can't do that?
I can't do that.
Okay.
No, I have a hip problem, and then I've got my knee.
Okay, so are you refusing
Gotcha.
to do the test then?
I don't want to refuse the test because I want to take my grandson back home.
Okay.
I have court Monday at 2:45. I know
I
what you're
understand
trying
that.
to do. I am not drunk. I haven't drank anything all day long. I will pass the BAC, whatever. I'm not going to be driving drunk with my f***ing grandson in the car. I tried turning around and the goddamn shit ate my car.
Okay.
And all I asked was that lady for her to help me get back to Hatley to where I'm not supposed to be at Anthony Labundi's house.
Okay. So are you refusing to do the one leg stand?
I can't guarantee that I can even do it.
Haley was then arrested because of reasonable suspicion of DUI.
No, you don't have. No, I want to touch my grandson. I want to talk to my f***ing grandson. I want to talk to my f***ing grandson. Baby, it's okay. I love you.
Get in the car, please.
You okay?
Sit down. Get in the car, please.
All right, baby.
Get in the car, please.
Stay right there. Papa's gonna come get you, I guess.
Hand me the cell phone.
Nope.
Hand me the cell phone.
Nope.
No.
You're gonna do this in front of your grandson?
Yeah, you're doing it in front of my grandson.
Nope, you are.
I asked you to f***ing let me just at least go home and drop him off. I will go with you guys.
Nope, we're gonna figure that out.
No, I will go with you guys. Just drop my grandson
Where's the
off,
cell phone
please.
at?
I don't have a cell phone.
Now she doesn't have a cell
I'm
phone.
back
Gosh.
here dripping like a Did you
Yep.
guys not understand
I have the eight-
epilepsy?
Yeah, well, that's what happens when you're kicking around like a child.
Okay, where's the cell phone? There it is.
You can leave it the
Let's
alone.
go to the front.
This is 2245, code 45.
All right. Yes, we will loosen the handcuffs in just a second. Listen to me, okay? Can you hear me? Haley, can you hear me? You can't hear me? Can you hear me? Okay. Under Wisconsin implied consent law, I am required to read this notice to you. You
There
have
it is.
either been arrested for an offense that involves driving or operating a motor vehicle while under the influence of alcohol or drugs, or both. Or you are the operator of a vehicle that was involved in an accident that caused the death of, great bodily harm to, or substantial bodily harm to a person, or you are suspected of driving or being on duty time with respect to a commercial motor vehicle after consuming an alcohol or an intoxicating beverage. This law enforcement agency This law enforcement agency now wants to test one or more samples of your breath, blood, or urine to determine the concentration of alcohol or drugs in your system. If any test shows more alcohol in your system that the law permits while driving, your operating privilege will be suspended. If you refuse to take any test that this agency requests, your operating privilege will be revoked and you will be subject to other penalties. The test results or the fact that you refuse testing can be used against you in court. If you take all the required tests, you may choose to take further tests. You may take the alternative test that this law enforcement agency provides free of charge. You also may have a test conducted by a qualified person of your choice at your expense. You, however, will have to make your own arrangements for that test. If you have a commercial driver's license or are operating a commercial motor vehicle, other consequences may result from positive test results or from refusing testing, such as being placed out of service or disqualified. In addition, your operating privileges will also be suspended if a detectable amount of restricted controlled substance is in your blood. Will you submit to an evidentiary chemical test of your blood? Yes or no? No? Yes or no?
Nope.
What is that? Okay.
For what? I didn't do anything.
Okay, you already said no. Then we're gonna get a warrant. It's okay.
Can you please?
Did you really cramp him down?
No.
In a fight? That would be the only way that I would possibly loosen him on there.
Well, I would prefer to double check. Yeah.
I'll do whatever the it takes to get these handcuffs loosened, please. They're hurting my hands.
We're gonna check them, but you're gonna face the partition. You're gonna face that way.
Fight. I don't care. I don't want to fight. I just want my grandson to go home.
He's gonna go home. Okay, face away from us. Nope, face away from us. Inside the car. Thank you.
Please. Ow, it hurts. Stop. Ow.
Okay. We'll keep
Stop.
it. Okay.
Okay. It hurts. I'll go with you cooperatively. Can we just please take my grandson back home
They
to my
are.
husband?
Already taken care of.
Please.
Okay, relax.
Please.
Here, let me do this for you. You know, I'm gonna swap you into these ones.
I'm not here to fight you guys. I don't want to fight you guys.
I don't think they said that they were.
I just want to say goodbye to my grandson. Get those motherfuckers off me. I gotta go home and change my mom's diaper.
Relax.
Don't put me inside, please. They hurt. They hurt. You know
Okay, I can fit a finger in them so they're not tight.
No, my husband just beat the shit out of me the other night. It fucking hurts.
Oh yeah, that's what she was saying. She was saying that her boyfriend beat her up the other night.
Oh, of course. You know, she's a victim.
It's ridiculous. Put the cuffs down. Let me see the other one.
I would go with another set.
Yeah. Well, she's gonna slip these if she can slip these. The chains, because the chains are smaller. So, I'm just gonna have to do them tighter and she's gonna...
What are you doing?
Stop.
You stop? What the are you doing?
Putting the cuffs back on you that you slipped out of.
Stop!
Oh.
This is why they don't get loosened now. So this one goes tighter.
No, stop right now. I'm gonna file a fucking. Oh my god, I'm filing a fucking report.
Ma'am,
on
everything's
both
being
of you guys.
recorded.
That's good because I'm gonna file a report on both you motherfuckers.
That's fine. That's
Okay.
your
This fucking little rookie Cal Kurosaki. Oh yeah,
Rookie?
you like Kawasaki mother. I'm not trying to fight you guys.
Yes, you
But
are.
you slipped out of the
I'm
cuffs.
not.
Okay, let me see.
Stop! You're hurting my fucking wrist. It's broken. Ow! No, stop. No, it's broken.
That is
Please let
perfectly fine
no.
because you're gonna slip out of them
No,
otherwise.
let it go a little bit, please. I just got in a fight a couple nights ago. I busted my wrist and I busted my leg. Please, it fucking hurts.
Stop.
Let me out. He's gonna make himself sick.
He's
Please.
fine.
He's not fine. Let me out, please.
No, you're not coming out.
I'm not gonna run. I just want to make sure
Nope.
he gets to his grandpa.
We're trying to call him now.
He's not gonna answer. Will you please? Just
Okay.
let me out.
Well, we're gonna.
I'm not gonna fucking run.
Okay.
I promise you that. I'm not gonna fucking run. Just let me go and like.
I'm not gonna run, I swear.
A little bit of fucking condolences. He's not getting this shit. Please. Please. I'm begging you. He's gonna lose his fucking marbles.
He's fine.
Let me out so I can go and make sure my grandson's okay. I will fucking let you take me. I don't care.
2264
Just make sure
Sheriff.
my grandson is okay.
I got a water bottle for him too. So what happened is she made it just off of Double D, not even a mile. She took the wrong corner. She tried to back up. She backed right down into a ditch, real deep. Tried to get out, couldn't. Somebody was flagged down. I don't know if it was by her. They just stopped to check on her. She was begging them to come get you to get a tractor or something like that to pull her out. In the meantime, they saw the child in the back and thought she was intoxicated, so they called us.
Okay.
So we went there. She's pretty intoxicated. So right now she's under arrest for OWI 3rd.
Okay.
And there's quite a few other charges are coming with because of her actions tonight.
Okay.
She was fighting with us.
She was.
So nobody got hurt.
Well, thank God for that.
But it is OWI 3rd, so it's criminal. Also because there's a child under 16 in there, that's criminal. So that kind of changes things. And there's resisting arrest. So then there's displaying the wrong plates on a vehicle, no actual registration, no insurance, like all of it.
Oh my God.
We did. We're
Just one moment.
we're trying to do what we could to help her out. She didn't help herself. Not at all.
Naturally.
And it's unfortunate because I like to think that we give everybody more than a fair shake.
Sure.
She tied our hands.
Okay.
She's been fighting ever since. So in the meantime, what happened is the investigating deputy, the primary investigating deputy, he's going for the blood draw with her.
Okay.
She is going to have to go to jail.
Okay.
This isn't something she can just get released for.
Right.
In the meantime, that's why I brought him and the dog here, because everybody saw that you were home. I'm like, well, I'll give it a try.
Well, I'm home because I was working on the tire.
Sure.
I got a flat tire. I'm getting ready to leave for up north.
Right. I get it.
Can you please take these things off me?
No.
I'm not gonna fight you. I was pissed off, yeah, because you guys are letting my grandson run around the goddamn road and there's cars going. Apparently you guys don't have. Where'd you put my phone? I want to
He'll
call
call
my lawyer.
somebody.
Unless he can be.
I want to call my lawyer.
Oh, he'll be the stamper, so he'll need.
I want to
Yeah,
call
he'll
my
just call
lawyer.
somebody in, I'm sure.
I would like to call my lawyer. Can you please give me my phone, please? I want to call my lawyer.
You can when you get to jail.
No, I'm gonna call my lawyer right now because you guys ain't gonna take my blood and you ain't gonna take anything else from me. I slipped into a goddamn bitch. And that was the problem. I'm not under the influence. I haven't been drinking. I don't have anything in my goddamn system. I have to go home and take care of my mom, which has dementia, and she's there by her f***ing self right now. And you fools are sitting here holding me for nothing. I want my phone and I want to call my goddamn lawyer right now.
Maybe something's on the post.
Hey, while we're at it, why don't we all just go and sit and have lunch for a while? Poindexter doesn't know what he's doing yet.
Poindexter. I haven't heard that one in a while.
I do give you props. I do give you props because it's usually the.
Affiant. Yeah. Signs it.
I want my phone and I want to call my lawyer right now. I hope you guys have your body cams on. Do you have your body cam on? Because I'm asking for my lawyer and they will not give me my lawyer or my phone. This is a You guys are totally disrespecting my rights as an American citizen. No.
Uh-oh.
Take off
Here we
the
go.
handcuffs and I can sit down the right way. It hurts.
Please sit down. Thank you.
Fine. Take off the handcuffs.
No.
Yeah,
I'll fight you.
they hurt.
Latch to
They're
the bed if
cutting
she
into my
keeps sitting
skin. They're cutting into my skin.
Nope, definitely not. You're not being loosened. You already ruined that for yourself earlier.
One time already when we loosened them for you.
Okay, where in the am I supposed to run to? The room across the way? No. Give me my phone. I want to call my lawyer.
Ma'am, you're in police custody. You cannot.
Yes,
talk
I
on
can
your
call my
phone.
lawyer.
No,
Yeah, that's one of my rights.
no.
Yeah.
You'll have time to do that at the jail.
Oh, that'll be time for me to out of you.
That's fine. Everything's recorded for you.
Oh my god.
Okay.
Because you guys are going to get sued the up.
All right.
Hey, you!
Hopefully you guys lose your
Hey,
job.
you!
Let my grandson run around on the road by
Bless me.
himself. Goddamn asshat.
Mm.
You.
Thank you.
It's more important to arrest me than watch my grandson. You guys are pieces of shit.
I'm not the one driving around drunk with him in the car.
I wasn't drunk. I'm not drunk.
Okay. He's not 3 years old.
He's gonna be 4. Excuse me. October 10th. Is that okay with you? Yeah, he is 3 years old. He weighs 75 pounds, and he is about 4 foot tall. Is there any other questions you want to ask?
Wait, I'm sorry. He's 3 years old and weighs 75 pounds? Is that normal weight for a 3-year-old?
Where is he?
Yeah.
I don't know. You tell me.
Yeah, with his family who's sober.
I am sober.
No.
Yeah. Sorry to tell you. Yeah, I am. I wish I wasn't right about now. It'd be a lot easier. But no. I am sober because I have to take care of him and my mom. Oh. Is that long enough for you? How long do you want to stand like this?
Oh my god.
A, B, C, D, E, F, G,
Oh my god.
H, I, J, K, L, M, N, P.
Stop.
Wait,
Wait, she can't even do it right.
Cross my eyes and tip my nose. I can do that. Not a problem. I haven't been drinking all day long. I'm gonna sit here on this rolling chair.
No. Because you're going to fall off and then you're going to
No,
blame us
I'm
for
not.
it. Stand
I'm
up.
not gonna fall
Sit on the
off
bed.
anywhere. What are you talking about?
If you don't stay there, I'm going to handcuff you to that bed. Do you understand me?
I'm not gonna fall off anywhere. I'm
Right.
sober as
I'm not
shit.
playing that game with you.
You guys are illegally detaining me.
No, you're under arrest.
No, I'm not. For what?
Property while intoxicated and for a warrant. You're not detained, you're under arrest.
I'm not under arrest.
You most certainly are.
Oh, because I have a warrant. Okay, excuse me.
And OWI.
I don't have OWI.
You do.
No, I don't. I'm sober as
That's fine. That's what you have court for, okay?
have court for what?
For the OWI charge.
Ain't nobody gonna draw my blood. I will sue the shit out of you guys.
You're more than welcome to do that.
I will.
Oh, I
I
ask you
will
that you
call
don't
Maria.
physically resist.
I will. No, say if you guys aren't taking my blood, I will physically resist.
You're gonna get another charge.
I don't think so. I will call my lawyer, and I will let her know how you guys are treating me right now.
You'll take the blood and then you'll...
You're not gonna take my blood.
Oh my god.
I gotta go. I gotta go. Please, I gotta go. I gotta go. There's something wrong. There's something wrong. I gotta go.
You gotta go where?
I gotta go.
You
Can I take Neil back down? Thank you. I'm gonna just do this hand right here.
Oh no, don't do it on my hand, please. Don't do it on my hand.
I have to, okay?
No, don't do it on my hand, please.
Haley, you'll be alright.
No, I won't. Don't do it in my hand.
I have to, okay?
You can do it right in
Oh.
there.
Right here?
Yes, do it right in there.
Okay,
Don't do it on
then
my
you gotta
fucking
stay
hand.
right here, okay? Can't move.
She can refuse, but it's an automatic revocation.
So if you stay just like this, we'll be all good, okay?
My understanding, if I recall what the guy said
Yeah.
with Wisconsin law.
I don't know, does that come back up? CBC or CBD or whatever? CBD oil?
Okay.
Does that come up for THC?
I'm not sure.
Well, let me know. You're a nurse.
I don't know if I'll be there. Agree to disagree.
Okay. Excuse me.
Okay, sure. Just because I don't want to argue with you, and I can tell that you're upset about it, and
Yeah, it's my baby. And what happens if he would have got hit and they were sitting there trying to arrest me or put handcuffs on me,
yeah.
and instead of paying attention to him and him get hit?
Well, fortunately, that didn't happen, though, right?
Well, thank God.
I know.
But still, it's upsetting. They didn't give a
Well, I see, like I said, I would disagree, but should we get going? All right.
I just want to go back home. I gotta take care of my mom.
May I carry that so you can escort?
Haley was charged with DUI, third offense, resisting an officer, and misdemeanor bail jumping. YouTube thinks you will love the video on screen. Click
No, shut up. Thank you very much, guys. That looks like that's the end of it. I really am not a big fan of this channel. It doesn't give you anywhere near the level of detail that Code Blue Camp gives you. And it's obvious that they're a freaking compilation channel, like easy peasy. But yeah. But thanks again, guys, for your for hanging out with me. No stream tomorrow, but I will do my best to be back on. Excuse me, back on the thing on Friday, okay? But I hope you guys have a good night. Take care of yourselves, and I'll see you next time. Please hit that like button on your way out, of course, and check out the Discord. See ya.